Hello, everybody. We are in Unit 3, Part 2. We have talked about real consent and capacity to contract, and now we're going to talk about illegality of contract. Illegality of contract is based on the basic premise that no court will lend its aid to a man who founds his cause of action upon an immoral or an illegal act. When we talk about illegality, we're talking about both immoral or illegal. Illegal contracts is one that is unenforceable as a matter of policy because enforcement would be injurious to the best interest of the public. There is only one exception to a contract that's in the illegal performance by one party makes it voidable. Otherwise, generally speaking, illegal contracts are void. Okay? It is relatively immaterial whether the policy forbidding the enforcement is declared by the legislator, meaning it's declared against this, there's a statute that declares it illegal, or if the courts have said this is against public policy and therefore it is illegal. It could be a number of things that violate a law or is against public policy. I'm not going to go through all these and I'm not going to read them all to you, but if you want to take a second to just breeze through them and restart, you are more than welcome to. Okay, let's talk about blue penciling. Blue penciling is if the court has an illegal contract that's void, but they are able to modify, narrow, or delete that contract or contractual provision so that the remainder of the agreement is enforceable, they are going to do so. So we'll still have a enforceable contract, but that section is void. Okay? I want to first talk about contracts that violate statutes. That means there is a law on the books and the subject matter of the contract is associated with an illegal purpose, or in the formation or performance of the agreement, the parties participated in illegal activities. Okay? What's important to note about this is that the illegality must relate to the contents of the contract and it cannot be just some other intervening force. And I'll kind of talk to you a little bit about that, how that works. So, certain agreements that violate statutes, an example is usury laws. So let's say there was this new law that changed the limits that on what you could charge on a loan, okay, interest rates, and you didn't know, you're a lender, right? And so therefore, you violated the usury rate, and that would be void. Now, a court may blue line that and just charge and just say, we're not going to void the entire contract because this has to do with just a percentage of interest. We are going to blue line and let you just pay the highest interest allowed by law and no higher. It just depends. A court may void the entire thing. Or let's say there's this law prohibiting creation of a landfill in environmentally sensitive areas and you weren't aware of it, and the whole contract is to create this landfill. That is going to be void. There's no blue lining it. There's no way to blue line it. You can't create the landfill without violating the statute, and it's void. So let's talk about contracts that are illegally performed. And an example of this is Anderson Limited versus Daniel. In that case, there was a statute that said if you sell artificial fertilizer, you have to give the buyer an invoice stating the percentage of chemicals in it. Okay, and if you don't, you're fined. Fined, not fine. The plaintiffs sold a quantity of this selvage as artificial fertilizer to the defendants, but they did not supply the defendants with an invoice. They refused, okay? So the defendant says, I'm not going to pay then because this is an illegal contract anyway and it's void, okay? The plaintiffs then said, well, wait a second. We have a defense to you saying it's illegal because this industry trade does not provide invoices for things like this, and it's going to be prohibitively expensive to do so. So really, this isn't an illegal contract. Well, the court said, when looking at the statute, let's look at whether it's simply the provision is to protect revenue or protection of the public. And if it's protection of the public, the contract would be illegal, and therefore the party at fault is not going to be able to sue upon it. And the plaintiff could not claim a reasonable excuse purely because the cost of providing the invoice was high. And even if it could have, the contract would still be illegal because the purpose of the statute was for them, the chemical or the contracts to be made without the chemical analysis, okay? What this court said is, this is in the performance, right? We have this contract. The contract's not, anything about it isn't illegal. But you have to provide this invoice, and you didn't, and that's part of the performance. What the courts say is this is not a void contract, but it's voidable, meaning if I'm the one that didn't participate in the legal performance, I can void this contract, but I could have held you to it because you were supposed to provide me the invoice that was supposed to protect me, the public, and you didn't. I can void it, but you cannot. How about when we have two parties who have a legal contract or illegal actions in the performance? This is what we have here in this case, Ashmore Benson Peace & Company. They manufactured 2 tanks, and there was a haulage company that agreed to carry the plaintiff's equipment, okay? And they said, hey, we know there's a statute permitting weight, but we're going to go ahead and load our vehicles up a little extra. We might even be able to save you a little bit, okay? And the plaintiff said, okay, you're fine. Go ahead, do that. And guess what? It toppled over and damaged all sorts of equipment, and the plaintiff wanted to sue. The courts held that the contract was void for illegality. The contract itself was not illegal. It had not been performed in a manner that was illegal but it had been performed not in a manner that was illegal with the knowledge of both parties. And so if parties enter into a contract and it's agreed that we're going to carry out this contract unlawfully, it's void. Void means we are not going to touch it as a court. It's as if it never existed. Okay? So let's move to agreements that violate public policy. Agreements to perform an act for which the person is not properly licensed. For example, in restrictive competition or contracts of adhesion or licensing statutes. So let's say we have a licensing statute in it you have to have a permit or registration before you engage in a certain business. Is the state regulatory or revenue, or is the statute regulatory or revenue raising? That's what you have to decide. Because if it's to protect the public against dishonest or incompetent practitioners, then the agreement with an unlicensed person is void. Okay, so if it's for something like character and skills, so if you you lose your bar license, and that was because we're out there to make sure you do X, Y, and Z to protect the public, and you don't have your bar license as an attorney, you are going to then have all your contracts are going to be void, right? But if it was just to raise money, then the agreement is going to generally become enforceable. So if it's just, hey, the statute required to pay fees, they didn't pay the proper fees, I think the contract's illegal, I want out of it, that's probably not going to happen, right? Because it's a matter of writing the check. It wasn't about protecting the public. So we have our first quiz question here, if you want to take a good look at it. The last answer says a contract not expressly prohibited by the statute but performed by one in an illegal manner. Question 2. This last one says a contract to transfer all parental responsibility for a child from a parent who has parental responsibility of a child to another person. Okay? After you take a look at the questions, continue on. Let's talk restraint of trade. What is restraint of trade? Well, that's basically restricting free market competition, and it can come in various forms, and most of them are in employment agreements, and they're known as restrictive covenants or non-competes. And basically, they must not be contrary to public policy. The burden of proof is that if you want to challenge that you have, for example, let's use non-compete. Let's say I want to challenge that non-compete agreement so it cannot be used against me, then the party who has the contract has and wants to go ahead and enforce it. I do want to enforce that agreement, so I'm going to take you to court to make you. They have to first just show it's not contrary to public policy. If they have done that, then the burden then shifts, and the party that doesn't want the enforcement has to show that, well, even if it's not contrary, it's unreasonably fair. Agreements and restraint competition. If the sole purpose of an agreement is to restrain competition, it violates public policy, it's illegal, void, we go nowhere from there. But if they can show that it was part of an otherwise legal contract, it's going to have a different result because parties may have a legitimate interest to be protected by the restriction on competition, non-competition clauses. So let's talk about those. They will enforce, generally, non-competition clauses are enforceable. They're good. They're fine. Courts go ahead. They want to look at them. If it serves a legitimate business purpose, it's reasonable in time, geographic area, and scope, and it doesn't impose an undue hardship. So let's look at this case. We've got NASC Services versus Jervis, and the plaintiffs operated this soccer camp. And the defendants were from the UK and were hired by them to work at the soccer camps in New York and New Jersey. Some of them began working with the New York Red Bull Association. When the defendants signed an employment contract with the plaintiffs, they signed a non-compete, a covenant not to solicit the plaintiff's customers, and a covenant not to disclose plaintiff's confidential information. They quit because because they had a disagreement and they believed they were being bullied, abused, and deceived. And that's why some of them began working for a Red Bull association. Well, the plaintiffs, NASC, sued because they said, well, you're violating our non-competition, non-solicitation, and non-disclosure. The defendants said, wait a second, our continued employment with New York Red Bull is necessary, right? Because first of all, they are sponsoring our visas. By the way, the clauses, the non-compete are over broad, and we're not taking any plain protected information from the plaintiffs, okay? The defendants would have been barred from working in a business, any place basically, if you look at it, in the world, and 5 of the 6 would be forced to leave the U.S. because they'd lose their employment. Well, this is what the court said. They provide no unique service nor possess any extraordinary skill that could harm the plaintiff if they continue to work for Red Bull or any other employment in the soccer industry. They have the plaintiffs have really no legitimate protectable interest, okay, from preventing them to continue to teach children how to play soccer. Because first of all, they were taking information that was just readily available. They weren't taking a list of clients or anything. And they said the balance of the equity support denial of this, your complaint. Because if we do this for you, then what's going to happen is their visas are going to be revoked. And this is oppressive and unfair. So this is not a valid legal contract for a non-compete. It is void. So in Kansas, non-competes, like other contracts, are automatically presumed to be valid. But only a legitimate business interest can be protected by a non-competition agreement. So remember, we need a legitimate business interest to say you can't compete. If it's just to avoid ordinary competition, they're going to say it's unreasonable and unenforceable. An employer has a legitimate interest to protect the following areas: customer contacts, training of employees, trade secrets, confidential business information, loss of goodwill and reputation, referral sources, and preserving the confidentiality of clients. So what they say is one of those would be, we could look at some of those to see if it's reasonable. But then we want to know, does that agreement create an undue burden on the employee? Does it harm the public welfare? This is very interesting. The Kansas says, hey, non-competes cannot harm public welfare. Are they reasonable in duration and regional limits? So legitimate business may be protected by a non-competition covenant. If the sole purpose again is to avoid competition, then guess what? We're out. I'm showing you the slide again so you know what is a legitimate business interest. And this holds true for many states. Let's talk about the undue burden on the employee, okay? A non-compete agreement that totally restricts an employee from working in a particular field is going to be less likely to be enforced, okay? Courts are more likely to enforce an agreement that allows the employee to work in the field if the employee pays a set fee to the former employer, which is called liquidated damages. So basically saying, if you violate this, you need to pay me a percentage of whatever money you make off those clients, okay? That's a liquidated damages clause. Let's talk about the public welfare requirement. Basically, courts are less likely to enforce a non-compete if it's enforced and it would leave a shortage of an essential public good. So for example, in Graham versus Chiraco, enforcing the non-compete would have left 700,000 people in northeastern Kansas with only one colorectal surgeon. And basically the court said, if we enforce this, we are giving the other surgeon a monopoly. And even though one additional surgeon is still not enough for the 700,000 people, having two is at least better. So we are not going to enforce this, and it is not good for the public welfare. So durational and regional limits. Durational, there's no maximum term for a non-compete, and the total amount of time can be enforced may depend on what area it is in the overall agreement as well. Courts have generally upheld up to 2 years, but they also have found longer can be reasonable under the circumstances. Region, okay? Courts have upheld something as far as a 5-mile radius, okay, a 30-mile radius, and even in some circumstances worldwide. If it has to do with the CEO of a company and that company has worked all over the world, they say you can't work with my clients anywhere you are in the world. So you can't go ahead and say you're working out of China and take my clients any more than you can the US. So the courts are going to look at that. In Kansas, like common law, basically in most states, you have to have consideration. And if you give someone a promotion or increase their responsibilities in return, the agreement as part of signing the agreement, that's sufficient, or you could give them a bonus. One thing Kansas courts have not determined is whether terminating, you firing an employee makes a non-compete unenforceable. Generally speaking, what'll happen is the employee will leave, and once they leave, the employer finds out they're competing, they don't like it, the employer sues. So they don't have a case yet on whether or not a employer fires their employee and then has the audacity to sue them for non-competing, for the non-compete clause as well. Okay, we're on quiz question 3. If you want to go ahead and answer that, and you can pause, answer, and then return. And here is 4, 5, and 6. Again, if you want to go ahead, go through that, pause, answer, and then return. Okay, we're going to briefly talk about a few other things. One is exculpatory clauses. What are they? Basically, you'll see them all the time. They're waivers. We will not be responsible or liable for any damages that occur. Basically, the courts will look and they are going to accept those waivers or acknowledge those as long as it's not a threat to public health or safety, okay? You have to look about public policy grounds and are they suspect on that. Also, they cannot be negligent in their actions. They cannot waive their own negligence. So they still can be responsible for their own negligent actions, okay? Unconscionable agreements. Basically, if someone does not have a meaningful choice in the contract with an unreasonably advantageous upper hand by one of the parties, it is going to be unconscionable. And they're going to say, listen, we're not going to necessarily honor these contracts. And when we do, if it is oppressively unfair, we are definitely not going to make someone sell the house to you. Specific performances where it's a remedy where you're saying, I specifically want you to perform by giving me something. And they're going to say, wait, we're not going to do that. And the UCC, just as we talked about before with blue lining, is that they can refuse to honor all of the or even part of the contract for the sale of goods, or they could modify it. They can just strike out the unconscionable part. Contracts of adhesion. These are take it or leave it, and they're usually on forms that say take it or leave it. Unless it's harsh or oppressive terms, the courts are going to enforce those agreements. Remember, keep in mind, courts want to honor contracts. They want people to enter into contracts and keep their word. They're not looking for ways to void contracts, okay? When you look at things, it's always public policy. Think of that as you're going. The statute, which most statutes are based on public policy. And here we have your final 10 quiz questions, and then you will be done. If you have any questions on illegality, please feel free to contact me.